Yesterday, Prince Andrew, the Duke of York, the King's brother and the second son of Her late Majesty Queen Elizabeth II, who has been embroiled for some years in scandal, I'm not interested in talking about that, put out a statement through Buckingham Palace in which he said the following: "I will no longer use my title or the honours which have been conferred upon me." Now, for a historian, that is really interesting. What does Prince Andrew actually mean by this? Well, there's a lot of speculation on the internet about it. Some say he's been stripped of his peerage titles, some that he has formally relinquished them, others that he has returned them to the king and the crown, and that his titles are now available to be granted to someone else. I've heard it said that his titles are now in abeyance or dormant, which are indeed technical terms for what can happen to certain peerage titles in some circumstances. But none of this idle speculation is remotely true, and the Prince's statement should make that very clear, as he refers to my title in the present tense. He hasn't lost, he hasn't relinquished, or been stripped of his peerage titles, or any of the honours that had been bestowed on him. He is just going to pretend that he doesn't have them anymore and not use them. He legally remains, as he has been since the 23rd of July 1986, the Duke of York, the Earl of Inverness and Baron Killalea. As I will explain in this video, for solid historical reasons, primarily to prevent our kings becoming out-of-control despots, it is nearly impossible to get rid of a British peerage. It is extremely difficult for an individual to relinquish one, and nigh on impossible for a peerage to be removed from an individual and their heirs. There are legal mechanisms for these things to occur in certain exceptional circumstances, but none of these, as I hope to show you, can possibly apply in the case of Prince Andrew. Before moving on to discuss all of this, what do we mean by the peerage? In a British context, the peerage refers to the noble ranks of Duke, Marquess, Earl, Viscount and Baron, titles that emerged from the feudalism of the High Middle Ages, and even in recent years, in most cases, there are a few exceptions, had social and political responsibilities automatically attached to the title, notably a seat in the House of Lords. In the United Kingdom, which is a union of formerly independent kingdoms, we have several different peerages that run concurrently. Before the Act of Union in 1707, England, Scotland and Ireland all had their own peerage systems with slightly different inheritance rules. For example, some baronies in England and several of the titles in Scotland can be inherited through the female as well as the male line. That will become relevant when I discuss the concept of abeyance later on in the video. In Scotland, baronies are feudal rather than noble titles, and the equivalent of a baron in the peerage of England is a Lord of Parliament in Scotland's peerage. In 1707, the peerages of England and Scotland were both replaced for new title creations with the peerage of Great Britain, with the peerage of Ireland remaining still a separate entity. But since 1800 and the Act of Union with Ireland, all new peerages have been created in the peerage of the United Kingdom. Now, although Prince Andrew's titles refer to York in England, Inverness in Scotland and Killalea in County Down in Northern Ireland, these titles were all created for him in 1986 in the peerage of the United Kingdom. So firstly, I want to address how someone with a peerage might rid themselves of it. Such an action was entirely impossible before 1963. If you inherited a peerage, you were stuck with it for life, and you were also saddled with the responsibility of being summoned to Parliament and sitting in the House of Lords. Although since the year 2000, most of the hereditary peers, including the Duke of York, have been excluded from the House of Lords. An Act of Parliament called the Peerages Act 1963 made it possible for the first time for individuals who had inherited a peerage to disclaim it for the term of their life. A peer could deliver to the Lord Chancellor what was termed an instrument of disclaimer and could be rid of the title and the attached responsibilities, although this had to be done within 12 months of inheriting the title. This Act of Parliament became law in 1963 after lobbying by several members of the House of Commons who'd inherited peerages. Among them was the Labour MP Tony Benn, who had inherited the title Viscount Stansgate from his father in 1960. Benn and others had their political careers in the House of Commons cut short through the inheritance of a peerage. For as a peer of the United Kingdom, you were automatically a member of the House of Lords, but you were barred from sitting as an MP in the Commons. Disclaiming a peerage didn't dissolve that peerage entirely. When the peer who had disclaimed his title died, the title would then go to their next heir. So when Tony Benn died in 2014, his eldest son Stephen became the third Viscount Stansgate. There are certain caveats to this act. Disclaiming a peerage is only an option for those who had inherited their title on the death of a previous holder. It is not possible to use this act to disclaim a newly created peerage you have been given. So Prince Andrew is the first Duke of York, although of the 9th creation, and as a newly created peer, he cannot legally disclaim his title through the Peerages Act of 1963. As this act is the only legal mechanism for an individual to get rid of their peerage, he therefore cannot relinquish it himself. What about being stripped of his title? Well, that's difficult too. But in the past it has happened, but only in very tightly controlled circumstances. Although the British sovereign has the power to create peers, and they do this through a letters patent with a great seal attached to it, they don't have the power to take peerages away. Charles III can make anyone he likes a peer. He could even make me one if he wanted to. But having made me a peer, he couldn't take that title away from me. To understand why that's the case, we have to go back to the early 13th century and to the reign of King John. John and his predecessors could strip their barons of titles and estates at whim. They often did this, they did it unilaterally, and they often did it punitively. Such behaviour caused conflict between the king and the barons, and at times caused civil war. Now, one of the clauses in the Magna Carta, agreed in 1215 between King John and his barons, curtailed the king's power to do this. It declared that no free man shall be seized, imprisoned, dispossessed, outlawed, exiled, or ruined in any way, nor in any way proceeded against, except by the lawful judgment of his peers, his equals. And so began the principle that peerages could only be taken away with the consent of all the barons, the whole nobility, and not by the king acting alone. When Parliament began to emerge in the 14th century from the Curia Regis, the royal court, it became the convention that the stripping of any peerage required an Act of Parliament that was passed both by the House of Commons, the House of Lords, and had the king's, the royal assent. The primary parliamentary mechanism for stripping peerages before modern times was the introduction into Parliament of what was called a Bill of Attainder, which, when it became law, became an Act of Attainder. This mechanism could only be used where cases of treason against the Crown were suspected. And as Parliament was the highest court in the land, passing an Act of Attainder confirmed the person guilty of treason without the need for a trial. An Act of Attainder went far beyond simply stripping an individual of their noble title, their peerage. It stripped them of all of their rights. They couldn't even own property or make a will. And it also corrupted their blood. The heirs of their body were prevented from inheriting any peerages or any property. The first attainder was used against Hugh le Despencer in 1321, who was a favourite of Edward II. And Henry VIII, of course, used attainders frequently to rid himself of his political opponents, including Thomas Cromwell and his Queen Catherine Howard. But Henry, even at his most despotic, knew that he couldn't strip a peerage from his enemies except through the proper mechanism of Parliament. The last attempt to attaint an individual was in 1820, when George IV tried to rid himself of Queen Caroline, his wife, and no attainder has been passed since, and indeed most of the legal basis for attainting individuals was repealed in the 19th century. However, the principle that an Act of Parliament is required to strip an individual and their heirs of a title has been maintained into the modern period, but it has only been tested once. Peerages were stripped from 4 individuals in 1917 during the middle of the First World War. The Titles Deprivation Act was introduced to strip titles from those who have, during the present war, borne arms against His Majesty or his allies, or have adhered to His Majesty's enemies. 4 individuals were affected by this act, 3 of whom were minor members of the royal family. The first of these was Charles Edward, Duke of Albany, the grandson of Queen Victoria and the Duke of Saxe-Coburg-Gotha. Ernest Augustus, Duke of Cumberland and Teviotdale, a great-grandson of George III and the head of the House of Hanover, and his son Ernest Augustus, Duke of Brunswick, were also stripped of their British titles. Lastly, Henry, Viscount Taaffe of Corran and Baron of Ballymote, who was also an Austrian count, lost his Irish peerages. So with an Act of Attainder out of the question, only a very specific Act of Parliament, a bit like the Titles Deprivation Act, could strip Prince Andrew of his peerages. And there would have to be a good reason to proceed with it, such as treason. I don't think his behaviour, however immoral it might be, judged by the public or the press, is grounds for such a legal proceeding. What then of the curious suggestion that the peerages of Prince Andrew are now somehow in abeyance or dormant? This is also legally impossible. Now, in the Peerage of England, some of the very earliest medieval baronies were created with inheritance that included the heirs general as well as the heirs male of their body, which allowed those titles to be inherited by women as well as by men. When a baron had no sons but only a daughter, she could inherit the barony directly. However, if a baron had 2 or more daughters, they were considered equal or co-heirs to the lands and titles of their father in English common law, and so neither of them would automatically inherit the barony. And in this situation, the title then went into abeyance between those daughters and their heirs. Now, this word abeyance in Norman French means a gaping hole, and is used in the sense that there is a vacant gaping hole to be filled in a barony. Very often the hole was filled, even after some centuries, when the abeyance was sometimes terminated by the Crown in favour of a particular heir, who then would inherit the title. Now, all 3 of Prince Andrew's titles were created in the Peerage of the United Kingdom and can be inherited only by his heirs male, so it is impossible for these titles to be put into abeyance. As for dormancy, this is indeed a state that peerages occasionally can be put into on the death of a peer. If there are believed to be heirs who cannot be traced, or if an heir comes forward who has insufficient evidence to prove their succession, a peerage might be declared dormant. When dormant, the peerage is still considered extant, but in a sort of suspended animation. They can still be inherited by a claimant. As Prince Andrew has not inherited, but has been granted his peerages by his mother through letters patent, I can't see how they can be declared dormant. Now, Prince Andrew's knighthoods are a different matter. He is a Royal Knight of the Order of the Garter and a Knight Grand Cross of the Royal Victorian Order. He holds both of these directly and at the pleasure of the sovereign, and the sovereign can, if he wishes, remove them. Now, 40 men in history have been degraded, as it is termed, from the Order of the Garter. Most of these have also been attainted. There was in times past a formal and rather dramatic ceremony for degradation that took place in St George's Chapel, Windsor. Garter, King of Arms, and the heralds would throw down the crest and sword that hung above the former knight's stall, along with the stall plate with their coat of arms on it. The heralds would then kick these objects the full length of the chapel and out of the west door of the chapel. I doubt it very much that Charles III will put his brother through this degrading spectacle. He will simply cease turning up on Garter Day. Prince Andrew might be stripped of his knighthoods, but I think that's unlikely. But he is stuck with his peerages. He can't get rid of his peerages himself, as there's no legal mechanism for him to do so. If Henry VIII didn't have the power to strip people of their titles without recourse to Parliament, Charles III, with much weaker powers than his Tudor predecessor, certainly doesn't have that ability. The only way Prince Andrew's peerages could be removed is through an Act of Parliament, and it would need to be one that was specific to him. I can't imagine the royal family wanting to go through that scandal. So although Prince Andrew has now chosen not to use his titles, he will remain in law Duke of York, Earl of Inverness and Baron Killaleigh. If he has a son, which is still conceivable, these titles would be inherited by him. It is most likely that at his death the titles will become extinct and revert to the crown, and can then at that point be given by a future sovereign to another member of the royal family. Thanks for watching. Over on my website yesterday I launched my antiquary calendar for next year. For 2026 the theme of this wall calendar is the medieval year, and it is illustrated in full colour with illuminations from late medieval manuscripts showing the labours of the months. It would make both a delightful and a practical gift for friends, family, or even as a treat for yourself. I have a very limited stock of these, and last year I sold out rather quickly, so if you want a chance of getting one, pop over to my website and grab one while you can. The link is in the description below.